Right to freedom of religion. Articles 25 to 28 indicate the following. All persons are entitled to freedom of conscience and the right to freely profess, practice and propagate their religion. So every person, they have the right to freely profess, practice and propagate religion of his or her choice. Subject to public order, morality and health, every religious denomination or any section thereof shall have the right. So any religion of any denomination or any section, they have these following rights: to establish and maintain institutions for religious and charitable purposes. Any person can want to establish and maintain any institution, any religious institution or any charitable institution. They are free to make that. To manage its own affairs in matters of religion, any religious matters, they are free to manage that without the interference of the state. To own and acquire movable and immovable property, they have the right to acquire any kind of movable or immovable properties. To administer such property in accordance with law. So these are the rights given to every religion. No person shall be compelled, means forced to pay taxes for the promotion of a particular religion. Like previously there were the religious taxes prevailing in India, but now there is no such kind of religious tax. Any person can profess, propagate and practice any religion. They can establish any religious institutions, but they will not pay tax for any kind of religious practice. No religious instruction shall be provided in any institution wholly maintained out of state funds. If any educational institution is maintained out of state funds, so there cannot be any kind of religious instructions being provided in those institutions. Even though religious instruction may be imparted in educational institutions recognized by or receiving funds from the state, no person attending such institutions shall be compelled to receive that religious instruction. If also in any kind of state funded institution religious instruction is being imparted, but no person can be forced to take such kind of religious instruction without the consent of himself or of his guardian, in case the pupil be a minor. So if the person wants, he can take this religious instruction, otherwise he cannot be forced. Then cultural and educational rights. Articles 29 and 30, protection of minorities. Article 29 gives a section of the people or whole of them to the right to preserve their distinct language, script and culture. Every person belonging to any minority, maybe minor religion, minor community, so they have the right to preserve their language, script and culture. In the matter of admission to any education institution maintained by the state, admission cannot be denied on grounds of religion, color, caste, creed or sex. So this already we have studied in case of right to equality, that every person has a right to get admission in education institution without any kind of discrimination. Minorities and educational institutions. Article 30 gives all minorities the right to establish and administer the educational institutions of their choice. The minorities, they also have the right to establish and administer educational institutions. The state is also prohibited from discriminating against educational institutions in the matter of grants. Even when funding, at the time of funding also, the state cannot discriminate educational institutions on the grounds of minorities, that the educational institution is run by minorities, so the state will not give them funds. The state cannot do any such kind of discrimination. Then right to constitutional remedies. Article 32. Fundamental rights are justiciable, that is, a suit can be filed in a high court or the Supreme Court if fundamental rights are violated. If any person is not given any kind of fundamental right, then he or she has a right to move the court of law, that is justiciable. Fundamental rights are justiciable. Article 32 gives the right to constitutional remedies. This right is given to citizens to move Supreme Court for the enforcement of other fundamental rights conferred on them. So according to Article 32, the person can move Supreme Court if the fundamental rights are not conferred on them. Dr. Ambedkar described this article as the heart and soul of the Constitution. This right to constitutional remedies has been mentioned as by Dr. Ambedkar as the heart and soul of the Constitution. In essence, it is not a right but a remedy. So we can say it more of a remedy than a right. It is actually a solution, but that is why it is called more of a remedy than a right. Under this article, the Supreme Court and the High Court within their respective jurisdiction, means where the High Court jurisdiction, are empowered to issue writs. So what is a writ? A writ is a formal written order issued by the Supreme Court and the High Courts to provide legal remedies. These writs are actually the written orders that are issued by the Supreme Court and High Courts to provide any kind of legal solution to individuals who do not obtain adequate protection under ordinary laws. If under ordinary laws they are not getting adequate protection, then these written orders can be issued by the Supreme Court and High Court, and these written orders are called the writs. As per the Constitution, the enforcement of the fundamental rights, issuance of writs, making of laws by the Parliament, and suspension of this right under very special circumstances, means under exceptional cases, have all been taken care of under different clauses of Article 32. So there are different clauses under Article 32, and every clause takes care of some or the other issues, such as some clause deals with the issues of enforcement of fundamental rights, some clause deals with the issuance of writs, making of laws by the Parliament, and suspension of this right under any kind of special circumstances. So all this has been mentioned in some of the other clauses of Article 32. Now we will study some important writs. First is habeas corpus. This writ definition, the important writs, is a very important. Habeas corpus, it means to have the body. By issuing such a writ, the High Court or the Supreme Court can get the body of any person released if it has been unlawfully detained by any person or a group of persons or by the state. If any person has been unlawfully detained, then the Supreme Court or the High Court has the right to free that particular person, to release that particular person. This writ is thus a great safeguard for the personal freedom of a citizen, so that that person cannot be unlawfully detained. So for that reason, this writ is very much important for the safeguard of the personal freedom of a citizen. The next writ is mandamus. In Latin, it means we order. It is a command or an order from a superior court to a lower or an administrative authority to perform a certain duty. So in according to this mandamus, it is actually the command or order that the superior court gives to either a lower court or any lower administrative authority to perform some kind of duty. Then writ of prohibition. The writ of prohibition is an order issued by a superior court to a lower court to stop proceedings in a case which might be in excess of the jurisdiction of the lower court. So every court, they have certain kind of jurisdictions, means limitations. If any lower court is performing any case that is beyond its jurisdiction, then the superior court can give the order to stop the proceedings immediately. So that is writ of prohibition. Then writ of certiorari. This writ is issued by a superior court to a judicial authority desiring to be informed of what is going on. So according to writ of certiorari, a superior court can ask the judicial authority or the lower court to keep informed of what is going on. Though it appears similar to the writ of prohibition, there is a difference. So this is the difference between writ of certiorari and writ of prohibition. Writ of prohibition is issued when certain proceedings are going on, while the writ of certiorari is issued after the order has already been passed by the lower court. So writ of prohibition, the proceedings are already going on and then this writ is issued, but in writ of certiorari, the order is issued has already been this order is issued when the order has already been passed by the lower court. So this is the difference between writ of prohibition and writ of certiorari. Then quo warranto, it means by what order. It is issued when a person has usurped any office, means taken over any office. This writ thus prevents public officers from forcibly or wrongly holding a high public office. So according to quo warranto, any public officer, any high public officer cannot use his arbitrary power to hold a office, to take the hold of a office. So that is restricted under quo warranto. The writs make the right to constitutional remedies the most important and also make it an effective tool for their enforcement. Though presently only the Supreme Court and the High Courts have the power to issue these writs, the Parliament can confer similar powers on other courts. So now for the time being, Supreme Court and High Court has the power to issue these writs, but if the Parliament wants, it can confer these powers to other lower courts also. The next is right to education. This right has been granted by the Constitution, that is 86 Amendment Act 2002. By this act, a new Article 21A has been inserted in the Constitution, which states the state shall provide free and compulsory education. So according to right to constitution, the state shall provide free and compulsory education to all children of age 6 to 14 years in such a manner as the state may by law determine. So it is compulsory for children from 6 to 14 years to get this compulsory education. So that is under right to education. Then right to property. Article 31 of the Constitution had earlier empowered the citizens of India to purchase, hold and dispose of movable as well as immovable property as fundamental rights. So in Article 31, previously it was empowered to the citizens, they can purchase, hold or dispose of any movable or immovable property. However, in keeping with the socialistic philosophy of the Constitution, the right to property was deleted from the list of fundamental rights. So now for the safeguard of state interest and national interest, this right has been deleted from the Constitution. The right to property was deleted from the list of fundamental rights by 44th Amendment Act 1978. This amendment made the right to property, Article 300A, a legal right. Then check on arbitrary actions of the state. The fundamental rights secured to the individual are in the nature of limitations or restrictions on the arbitrary actions of the state. So these fundamental rights are a kind of freedom to the citizens but restrictions to the state. Article 13(2) declares that all laws and executive orders in force immediately before the commencement of the Constitution, inconsistent with the fundamental rights, are void to the extent of such inconsistency. So, according to this Article 13(2), all laws and executive orders in force immediately before the commencement of the Constitution, inconsistent with the fundamental rights. If it is inconsistent with the fundamental rights, not matching with the fundamental rights, are void to the extent of such inconsistency. This article thus provides for judicial review of all legislations in India. So if it is against the fundamental right, if the law is against the fundamental right, then it can be declared as null and void. However, the Constitution has empowered the state to make valid exceptions to the rights on the grounds such as security of the state, public order, public morality. Already we have studied this kind of exceptions when it comes to national interest. Then restrictions imposed. Fundamental rights are not absolute. Reasonable restrictions can be imposed on them because of the general welfare of the society, because the welfare of the society or national interest is of paramount importance in comparison to individual interests. So that is why certain restrictions has been imposed on fundamental rights. The fundamental rights can be suspended when the President declares a state of emergency in the country in case of war, external aggression or armed rebellion. So the fundamental rights can be suspended in case of emergency if the country is facing some kind of war, external aggression or armed rebellion. Such a suspension of rights is temporary. So these suspensions, they are actually temporary in nature. As soon as the emergency is over, the rights are restored back, means brought back. For the security of the state and national interest, reasonable restrictions on fundamental rights can be imposed. So for the security of the state, for national interest, the state can impose restrictions on fundamental rights. Parliament has the power to modify the application of fundamental rights to the members of the armed forces, police force or intelligence organizations so as to ensure proper discharge of their duties. So the power to modify the application of fundamental rights to the members, the members of armed forces, police force or intelligence organizations, they have the power to modify this application of fundamental rights so that no problem comes at the time of discharge of their duties. There are some laws which restrict the use of these rights in public interest, like the Maintenance of Internal Security Act, MISA, Defense of India Rules, DIR, Preventive Detention Act, PDA, the National Security Act 1980, NSA, Essential Services Maintenance Act, ESMA, are made to safeguard. These are some of the laws that are made to safeguard the interests of the nation, but they curtail the use of the fundamental right, because these are the laws that are more for the interest of the nation than the individual interest. So that is why they curtail the use of fundamental rights. Then suspension of fundamental rights. The fundamental rights guaranteed by the Constitution remain suspended while a proclamation of an emergency. We already studied that during national emergency, these fundamental rights remain temporarily suspended under Article 352. As soon as the proclamation of such an emergency is made, the legislature is free to make any law, and the executive has the liberty to take any action, even though it restricts the right to freedom of speech, of expression, assembly, association, movement, residence, profession, or occupation. So once this restriction is imposed on fundamental law, the fundamental right, the legislature can make any law, and the executive can execute that law, even though it restricts all these fundamental rights. These restrictions remain in effect only as long as the emergency is in operation. This also we already studied, that these restrictions are only temporary in nature till the emergency exists. When a proclamation of emergency is in operation, the President may by order declare that the right to move a court for the enforcement of fundamental rights shall remain suspended. So when this emergency is proclaimed, that time the person, the individual, when he is not getting his fundamental right, he cannot move the court of law. That also remains suspended. The movement to the court is also suspended during the time of emergency. In case of such a situation, the Supreme Court and the High Court shall be powerless to issue the writs or to make any other order for the enforcement of any fundamental right. So any law on fundamental right, everything remains suspended during that time period. Even the issuance of writs by the Supreme Court and High Court also stays suspended. Then fundamental duties. So we already know, everybody of us, we know that duties and rights go hand in hand. If we are getting some kind of freedom, some kind of privilege, that means we also have certain kind of duties towards our country. If the country is giving us some kind of privilege, that means we also have some duty towards our country. That is why here it is written, duties and rights go hand in hand. It is not like that the country will give us all the rights we require. It also wants something from us, that is fundamental duties. There can be no rights in a society where there are no duties. For example, if we have a right to life, it is our duty to respect others' life. If we have the right to live or life, that means we also have the duty to respect others' life and not to injure another person, because that person also has the right to live. Similarly, the right to freedom implies that we have to maintain self-restraint and accord similar rights to others which we want for ourselves. Right to freedom also says that if we want certain kind of freedom, then we also need to respect others' freedom also, so that we can also live happily and they can also live happily. It was in keeping with these ideals in view that fundamental duties were incorporated in the Constitution of India. So these are the fundamental duties. Kinds of duties. The fundamental duties were added to Constitution by 42nd Amendment Act 1976 and inserted in Part 4 of the Constitution. This is very important. It was incorporated in 42nd Amendment Act 1976 and inserted in Part 4 of the Constitution. Fundamental right was in Part 3 of the Constitution. Fundamental duty was in Part 4 of the Constitution. The Article 51A of the Constitution states the following 10 duties of a citizen. So these are the duties that the country wants every citizen to fulfill. What are the duties? To abide means to obey by the Constitution and respect its ideals and institutions, the national flag and the national anthem. To cherish and follow the noble ideals which inspired our national struggle for freedom. The ideas that inspired our national struggle for freedom, we should follow those ideals and we should cherish them. To uphold and protect the sovereignty, unity and integrity of India. It is our duty as a citizen of India, it is our duty to uphold and protect the sovereignty, unity and integrity of India. To defend the country and render national service when called upon to do so. Whenever we are required to defend our country, we should move forward. To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities. So there should be harmony, there should be a spirit of common brotherhood irrespective of religion, language, regional differences, sectional differences. To renounce practices derogatory to the dignity of women. Any kind of practice that is derogatory, disrespectful to the dignity of women, those kind of practices should be renounced. Is given up. To value and preserve the rich heritage of our composite culture. The composite, we have such a rich, diverse composite culture. It is our duty as Indian citizens to value and preserve this rich heritage. To protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and have compassion for living creatures. It is our duty to protect and improve the natural environment, to protect the forests, lakes, rivers, and wildlife, and also to have love and passion towards living creatures. To develop the scientific temper, humanism, and the spirit of inquiry and reform, we should develop the scientific temper within us, scientific reasons within us, humanism, and the spirit of inquiry. Instead of believing anything falsely, we should have the spirit of inquiry. To safeguard public property and to abjure violence, we should not do violence, any kind of violence. We should have the duty, we should fulfill the duty of safeguarding public property instead of doing any kind of violence. To strive towards excellence in all spheres of individuals and collective activities, so that the nation constantly rises to higher levels, and towards any excellence, if we can contribute to any kind of sphere or any kind of field we can contribute, we should contribute in that, so that the nation gets to rise to higher levels of endeavor and achievement. It is the duty of a parent or guardian to provide opportunities for education to his child, or as the case may be, between the age of 16 and 14 years. It is the duty of every parent or guardian to see that his child gets education from 6 to 14 years. The clause K was added to the constitution. This is another important fact, that the clause K, this right to education, was added by the constitution 86th amendment act 2002. Importance of fundamental duties. To make the citizen aware of their social and economic obligations, means the Indian citizens, these fundamental duties has been incorporated to make the citizens aware that they have certain social and economic obligations towards their country, to warn them to do and not to do certain things in the interest of their country, fellow citizens, and themselves. To protect and awaken the people to their cultural heritage. The people should be aware about their cultural heritage. To tame the unruly elements in society, some antisocial elements of the society, they should be to tame them. These fundamental duties has been incorporated. To strengthen national harmony, as they strive of patriotism, there should be national harmony. All these fundamental duties strengthens national harmony, and all these fundamental duties, they strengthens national harmony and bring up the spirit of patriotism.